The accused in the 280 million rand Estina Dairy case have applied to the Free State High Court to have the matter struck off the rolls, citing undue delays. Their lawyers have requested the court postpone the trial to tomorrow. Now, this is to allow them time to submit replying affidavits after the prosecution responded to their application. They say they were ready for trial, but prosecution delays have now rendered them not ready. The matter was revived back in 2022 with new arrests, including that of former Mineral Resources Minister Msebenzi Zwane. The accused in the Estina scandal were first arrested back in 2018 before the matter was provisionally withdrawn. Former department head Peter Tabete, Chief Financial Officer Sipati Dlamini, Gupta associates Ugeshni Govender and Ronika Raghavan are among the accused. Justice Celeste Reinders has given the accused until 9 a.m. tomorrow to file their replying affidavits. All right, to discuss today's court proceedings in that Estina Dairy case is legal analyst advocate Mpilo Baloyi. Good afternoon, advocate. Thank you very much for joining us on The Full View. So the matter has been postponed, with the defense looking to have the matter struck off the roll due to the inordinate delays. It, of course, wouldn't be the first time, as you heard in that intro, because the NPA had struck the matter off. It was re-enrolled. Your take on the most recent application now brought by the defense?
Good evening, Fundo, and good evening to our viewers. Indeed, this is a very interesting matter. What we really have to consider is that justice delayed is justice denied, and there is a lot of merit, particularly in the application that has been brought by the accused, because they have a right to a fair and a speedy trial, and the further postponements jeopardize them. And indeed, the Criminal Procedure Act does call for a matter to be struck from the roll pending the readiness of the state. Now, what we must consider is that postponements are not only occasioned by the state. There are also instances where the accused themselves may need indulgence from the state for the purposes of their own readiness. So in this regard, if we look at the delay and the time that has lapsed from inception of the matter to date, indeed, there has been delays, and if we'll remember, the previous postponements were also due to the fact that the state had not yet collected enough evidence, and that's why the matter was provisionally removed. But now, one would assume that by the time it's re-enrolled, then the state should be ready to proceed to trial.
But at the heart of the recent delays, when it was just after it was re-enrolled, is the back and forth on the origin of the Gupta leaks hard drives that one witness will testify about, whether acquiring them was lawful, legitimate and authentic. Just talk us through the admissibility of such evidence, because it's really been at the heart of these delays now, where they were forced to get the hard drives. That if you're going to talk about Gupta leaks, we need the hard drives.
Indeed. I think, the state, we must bear in mind that the state has an onus to prove its case beyond a reasonable doubt. And as such, it has to have watertight evidence. And in this application for the matter to be struck off, it's also for the state to put forward their submissions as to why they feel the matter should be further postponed and what are the difficulties in obtaining the evidence that they ought to have obtained, or what are the delays in actually obtaining what is still outstanding.
But when we look at this matter, it's one that has also been ventilated in the State Capture Commission. Would it not be easier in this respect for even investigators and the NPA to have a quite stronger case, because there's a lot of documentation?
Indeed. Well, firstly, we must say that when we see matters being prosecuted, especially matters that emanate from the state capture inquiry, we are then confident that somewhat the wheels of justice are beginning to turn.
And because the groundwork has been done to a certain extent for you.
Of course, but now remember, the issue of proving the state's case beyond reasonable doubt, it does not only depend on the groundwork. There should be actually evidence that pins this particular accused to the particular crime which has been offended. So if they feel that there are still certain evidences or evidence that is outstanding, the state should be given an opportunity, in my view. So both the interests of both parties should be balanced.
So in this instance, would you say if the NPA is not ready now, they should allow for the matter to be struck off yet again and give themselves the opportunity to thoroughly investigate and have all the evidence at their disposal to ensure successful conviction, and perhaps not be pressured by society that wants to quickly see some of these matters actually concluded?
Exactly. And I think what I was going to say is that even though the wheels of justice grind very slowly, they grind quite finely. And this matter has been previously removed from the roll before, pending further investigations. And if indeed those investigations are still ongoing, there's nothing wrong with removing the matter and re-enrolling it once the state is ready to proceed, instead of having these accused going back and to and from court, and also incurring a lot of legal costs.
Because the appearance of your legal representatives means you must pay money. Advocate, thank you very much for joining us this afternoon. That's Advocate Mpilo Baloyi, legal analyst there, speaking to us about the Estina Dairy case that was sitting or being heard today.